Back to Senate Judiciary. We're taking up H534, an act relating to sealing criminal history records. And we have Lori Canty, Director of Trial Court Operations for the Vermont Judiciary. Lori, welcome.
Well, thank you. Thank you. So I'm here to discuss the mechanics of what will occur if this bill is passed. We have established procedures for sealing and expunging cases, and we understand the passage of the bill would increase the number of petitions we will receive. If the committee would like, I can explain a step-by-step process for when a case is sealed by petition.
That would probably be helpful.
Okay, I won't get too granular, but I can tell you we have a total of 34 steps that the staff take in addition to the judge's piece and following a sealing or an expungement process. I won't follow each one in detail, but I'll give you an overview. So first we receive the petition and we can get it either filed on paper, we can get it through email, or we can get it filed electronically through our electronic filing system. We then have to open up our case management system and add the petition into the case. While we're in there, we check to see if there are any outstanding fines, surcharges, or restitution that are due. If there are, we send the petitioner a form that advises them that they're not eligible at this time because of the outstanding balances and what needs to be paid. If that occurs, then we check the case regularly to see if those balances have been paid and the petition can proceed. If the petition is not filed as a stipulated petition, in other words, the state hasn't signed off saying that they agree to it, we would then send a copy to the state's attorney's office for their review. And we would create a time standard for ourselves to follow up on it after 17 days. If we receive a response from the state or after the time has elapsed, we then get active in the case again. We go in and we create a task for the judge to review the petition and send it to the judge. The judge then does their review and they will send us an order back in the case management system. We then take several steps to close out the motion. We have to update the decision. We have to send copies of the order to all of the parties. And they are usually the arresting agency, the Vermont Crime Information Center. We would copy the Department of Corrections if the defendant was on probation. If there had been restitution due in the past, we would copy the restitution unit so they would know to seal their records. And if it's a Title 23 offense, we would copy the Department of Motor Vehicles. If it's a partial sealing that was ordered, we then go into the case, and in each charge listed under the charge, there are 4 sub listings. Their case filing, plea, decisions, arrest. We would manually click on each one of those and change the code to sealed. This would change everything in our case record that referred to that charge to sealed. The only exception would be any documents that had been filed that included that information. It would not go back through and redact those documents. If the entire case is sealed, we then go in and change the case status to sealed, which makes it non-public. It makes it a confidential case status. Expungements would proceed in a very similar manner. Towards the end, when instead of going in and marking the cases as sealed, we would mark them as expunged. If the entire case is expunged, we have an expungement event that we can use that expunges the entire case. If only some counts are expunged, then we would go into those counts again and mark them as expunged. We then go to a SharePoint site and we manually add the case to an index. They're listed by county, and we attach a copy of the order. We note the docket number, the name, the date of birth, the disposition, and the type of order. So if a case were to become unsealed, we would have to change the case status back to public limited. If it was a single charge that was unsealed, they would need to look at the order and change the charge back from sealed to what it was prior to the sealing. And our prior case management system that we used before, the Odyssey, is now read-only. So we don't need to physically seal or seal the record in the case management system because it's not accessible to the public, but we would still take that previous paper file that we had and we would physically seal it in an envelope, and we would mark on it what the case was and put it in a secure location with other sealed cases. And so if it's a two-step process, so if it's a, the bill doesn't pass as written and we have cases that are sealed and then expunged, it's all of those steps, but twice. We would do the sealing, and then when the case becomes eligible for expungement, we would have to go through and start back at the beginning with the 34 steps that we take to expunge it.
Okay. Wow, that's quite a lot of work.
It is a lot of work, yes.
What is the backlog? Do you know?
I do. We do have, so we've been gathering this information. As of March 23rd, there were 7,781 non-conviction expungements in the pipeline awaiting processing. Some of those are ones, however, that include outstanding fines or surcharges, so they can't be expunged at this point. Some also have plea agreements that state that the state would object to expungement, so they may not be eligible to be expunged. We're doing the diversion expungement still. There are 195 outstanding. Those are the ones that were previously sealed and need to be expunged. Again, some of those may owe a fine or surcharge, so they're not eligible at this time. For deferred sentence expungements, we have currently 1,112 awaiting expungement. Again, some of those still may have a outstanding restitution or a public defender fee.
Well, that gives us 7,000 is a lot of cases.
It is a lot of cases, yes.
Can you tell me how common, if you have the figures, maybe you don't, how common plea agreements are where the defendant and the prosecutor agree that the case cannot be expunged?
It seems to be becoming more common. I think initially it was primarily cases that were, it was dismissals that were dismissed because of a finding of not competent to stand trial. But I know that some counties note that more frequently than others, but it seems to be becoming more common. I wouldn't say it's a high percentage now, but it seems to be gaining in popularity.
Is there any way of getting an accurate figure by county?
I don't think that's a metric that we can run a report on. I could look into that though and let you know.
I would be interested in knowing if it's becoming a way to, part of the plea agreement is you agree never to have your record expunged. Kind of goes against what we're trying to do. And if it's a geographic thing, it would also be problematic, I think.
Right. I have heard that it's Windham County is the county where I've heard it mentioned most frequently, but I can see if we can capture that.
Oh, Senator White, maybe.
Thank you.
Other questions for Laurie? Senator Nitka?
Very good information, Laurie. It's surprising, but tremendous amount of work.
Thank you very much.
I do have one question. So with regard to the, you said you have when the paper record is to be, sealed, and you have a special file for that. Are there times when that file goes to the archives and gets destroyed? Or do they just stay with you forever?
In the past, they've stayed with us forever, and it's created some space issues. We are able to send sealed file boxes to archives. I don't know if there's a destruction order on those, so I would have to check on that, whether they're ever destroyed.
Okay, thanks.
I'll tell you, most of us have bullets with lots of boxes.
Senator Benning.
Laurie, I'm curious, Odyssey and the portal, how do those folks get notice that something's been sealed?
Right, so it's actually because we're about to seal it, we can't send out notice electronically as we normally would for something that's in the case management system. So we have to physically send out a copy of the order. because as soon as we finish processing it, the case is going to be marked confidential and no one would be able to access it through the portal. So we send a copy to the defendant, all of the parties listed in the case.
I've seen several cases on the portal that are marked at the top confidential, but I still have access for some reason. I don't know.
Maybe
if that-
because you have elevated access as a party to the case.
Okay. Interesting.
Other questions for Lori? Lori, thanks so much for taking the time to join us this morning. We appreciate it.
You're very welcome. Thank you.
Our next witness is Aaron Jacobson from the Attorney General's office.
Good morning.
Good morning.
Thanks for inviting me back today. Nice to see you all again. For the record, Aaron Jacobson from the Community Justice Division at the Attorney General's office. And I think I can be fairly brief this morning because the Attorney General's been very consistent in his view on this bill, and that really hasn't changed. So as we've testified in the past, the Attorney General supports expanding the list of crimes that are eligible for record clearance. But as we've also testified, we really can't support an iteration of a bill that would move us away from the current protections under currently existing expungement law toward a sealing regime that provides broad access to law enforcement and DOC. We fully agree with the Joint Justice Oversight Committee's recommendation that any sealing regime should really favor confidentiality and that any access to records should be very limited and specific. I know a lot of questions have come up about the juvenile sealing regime, and Marshall mentioned that that statute is 33 VSA 5119. So just as an example, it's absolutely true that when juvenile records are sealed, then any access by any agency is very much limited. It's very specifically stated in statute what those purposes can be, and the statute is very specific about the process. So just as an example, 33 VSA 5119 F4 talks about law enforcement access. And this language very much mirrors the other provisions for other agency access, but it says, upon a confidential motion of a law enforcement officer or prosecuting attorney, the court may permit the department or agency to inspect its own files and records if the court finds extraordinary circumstances in which the state's interest in public safety clearly outweighs the purposes of the juvenile sealing law and the privacy rights of the person who are the subjects of the record. So it's very limited, it's very specific, there's a court process, and then the agency that wants to access the records can only access their own records. So if that's the direction that the sealing regime needs to go, I think we could consider that. But again, it would need to be very specifically and narrowly tailored in statute. What law enforcement wants and currently has access to in sealed records that are not juvenile, so this is very few situations, is criminal justice agencies have access for criminal justice purposes. Joint Justice Oversight Committee thought that was overly broad. The Attorney General feels that's overly broad and also counter to the science and counter to the purpose that we're trying to realize here with allowing people to move forward with their lives once they've had a brush with the law sometime in the past. I would also just want to emphasize that the currently expungible crimes and then the small list that would be added that would be now sealable It's certainly not everything. It's a very, very carefully curated list, taking into consideration that it's primarily nonviolent crimes, not crimes against people, not crimes against children, not crimes against vulnerable adults. And the only additional crimes, as the Defender General pointed out, is some minor property crimes and drug sales. So again, no, we do not have automatic sealing in Vermont, nor do we have a regime where everything is expungible or sealable. And so that's kind of the balance to then who can have access. We're carefully considering what can be cleared from people's records so that therefore they can move on. And the purpose for any access whatsoever really should be supported by the science. I really appreciated David Diamora's testimony this morning about DOC access and how old records really have, they're not helpful, they're not predictive, they should not be considered in future needs and risk assessment. And in fact, if we're talking about risk, the real risk is that that old information might be misleading, or that there could be a compounding of formally biased decision-making on what needs to be considered now, meeting people where they're at in currently existing situations. So that's really where the Attorney General's office stands. Again, strongly support expanding eligibility of certain crimes for record clearance. Do not intend to then make it so that we can't do background checks for firearms. That would be an unintended consequence. There's very few crimes in the expanded list, not in the currently existing expungible list of crimes, but in the list that would now become eligible under this bill, that would also prevent somebody from getting obtaining a firearm, and it's just the drug sale. So if VCIC needs to retain access to sealed records for the purpose of firearm background checks, that's an example of something that would be very specific, very narrowly tailored. That kind of thing seems to be reasonable, seems to be in line with the purpose of record sealing while also not infringing on public safety. But beyond that, general law enforcement access for law enforcement broadly stated purposes on the side of the road, that's not something that the Attorney General's office could support. And if that means that we just retain the current expungement law that we have and make sealable an expanded list of crimes, that could work too. But to take away protections that exist in current law is not something that our office could support. And I'm happy to answer any questions people might have.
I think that's pretty clear. Are there questions for Aaron? So one possibility is just adding crimes that could be sealed and using and providing access to those for those crimes.
Right. So that expanded list of eligible crimes under H534, if to get that bill passed, just those crimes are sealable only, not expungible, we could maybe live with that. But not to backtrack on the current protections provided under current law, making the current list of eligible crimes expungible. I would say one just last thing that I forgot to mention. We were a little disappointed that the establishment of the study committee to look at automatic sealing was removed by appropriations, and I understand that had to do with per diems. I would just say that if anyone is interested in continuing to look at that, that we would very much support that, and we'd be happy to assist in that in any way that would be deemed helpful.
I was thinking of drafting it so that the Joint Legislative Oversight Committee looks at it. Rather than-
I like that idea. And they've certainly had some experience with the sealing and expungement regimes. So
rather than creating a new committee. I wasn't aware that it had been removed by, it's in our draft of the bill that we've been looking at, because so I wasn't aware it had been removed by the House Appropriations.
that's my understanding. If I'm wrong, then great.
Yeah.
But I do think that's something that should be looked at carefully. And I think too that the director of trial court operations testimony kind of shines a good light on the process and the amount of work that it means for courts. I would hope that with upgrades in our case management systems, this all gets easier. But it's also true that many people who could get their records expunged don't even try to do that.
Right.
There's a lot of studies that show that.
Okay. Thank you.
Thank
Are there any
you.
other questions for Aaron? Thanks so much. Appreciate your testimony.
You're very welcome.
Appreciate the
Thank you.
Attorney General's position on this.
Okay.
Is Michelle available yet?
She's right here. Here.
Oh, I couldn't see her. Sorry. This- Okay, good. Well, Michelle, nice to have you with us. I don't see you.
I don't know where. Oh, there she is. She is there.
Oh, okay.
Just sitting in my usual chair.
Okay, maybe you want to take the witness's chair? Or bring your own chair over? Whichever you'd prefer. That red chair is so much more comfortable than the witness chair.
Easy to get it over there, though.
I don't like sitting in the witness chair now because I can't see you.
Well, you have a halo over you from here. I think we're at a point where the exceptions are far outweighing the point of doing the bill. And I have a sense, and committee, please, your views are helpful, but I have a sense that we either go in one of two directions. We use the juvenile model, which I think has been there forever, at least the last 30 years that I'm aware of, 40 years, 50 years of sealing, which I have not heard of necessary problems or any huge problems with sealing of juvenile records. Or we could do what the Attorney General's office just suggested and take the new crimes that are in and apply them to the way the House passed the bill, but not taking away protections that are currently available for the crimes that are not newly added. I don't know where the committee wants to go. But Senator Baruch.
Yeah, I think the second option I'm not as excited about because it continues this double track system, and we're okaying a new set of crimes and saying those are going to take place under this, and then the other set of crimes are going to take place under that. And it seems like it will continue confusions as we go forward and calls to simplify. But the first option that you laid out, as long as it was not burdened with a lot of exceptions, or as long as it remains pretty much what we have for juveniles, then I think that could work for me.
So could I add something? So Senator Sears, I was looking back because I remember working extensively with you on the juvenile ceiling law. And I was just looking back to see when we did that. It was 2008. And you came up with, because it used to be that you would have to petition for the sealing, and then you
Yep.
switched to an automatic after
Yep.
a certain period of time. And we did spend a lot of time on looking at who should have access and when they should have access. And what I can do, and I know you guys have looked at 5119, but I can pull that up into a draft, and maybe you could take a look at what's under 534 in the House proposal in terms of accessing sealed records compared to what you have in the juvenile sealing law. And that, I don't know if that would be helpful for you to kind of see the differences in the two. And then you can kind of maybe choose from a menu of options there if you're focusing on the access piece.
Well, I think that's generally what my concern is the amount of access that's provided. I can understand law enforcement purposes. I think it's actually counterproductive if DOC gets access to old records in making a risk assessment. That just what David Diamora signaled, and what his conversations with the developers of those assessments is that it actually could cause the risk assessment to be inaccurate.
Mhm.
So I'm not. There's no way I want to give out information that might ruin a risk assessment. So, despite DOC's insistence, and I'm comfortable with the juvenile system. There are times when a juvenile will be on a juvenile based upon that record is on the abuse registry, but they have, when we worked on that bill, we provided for appeals to, I think it's the Human Service Board, is it not? I can't remember, but you can appeal your being on the abuse registry. So if somebody's on the abuse registry for a crime that's either dismissed or I would agree with Joe, though, that if they're found not guilty, they probably shouldn't be on the abuse registry. They've been found not guilty of the crime.
Is there a time period for appeals?
I can't remember. I think it's a couple of years, yes.
I'm just sitting here thinking the trial that I had on Friday was a 2019 case. And if the appeal period had run and they left him on there, I don't know how he gets relief at this stage if there's a...
I think there is a time period before you can apply, but I don't think once that time period is, you're allowed to apply. If I remember correctly, and again, are you familiar with the practice of people agreeing to a plea agreement and then agreeing not to ask for that crime to be expunged?
I had never actually heard that until this morning, and if that was ever presented to me, I would tell the prosecutor to go pound sand. And I can think of one in my area who might be tempted, but that's the first time I'd ever actually heard of it.
Yeah. Well, if it's because given the nature of the crimes that are expungible or would be sealed under this bill, there's still a rather limited list. So yeah, are there crimes that are on the list that that shouldn't be or should be added to, particularly in misdemeanors?
If you look at are folks using the House Pass version? I just
Yeah.
have this printed.
Well, actually, I have the draft 5.2 of 534.
Yeah, that's what we've got. It wasn't, yeah, this one wasn't available when we first started taking it out. Thank you. I have a copy here for you, Senator Sears. I'll leave it by your desk.
Well, I did bring up violations, which are misdemeanors of the sex offender registry, which could be as small as you're not residing where you said you were. And they can be some major things, but they can be minor, the registry requirements. And the reason that, as I remember, after the Brooke Bennett case, we established this because of this, the perpetrator had violated some and it wasn't reported to the Department of Corrections by the parole officer or probation officer. But that's just one example. And I realized that violations are serious, but if you're talking about expungible things, although probably the crime couldn't be expunged anyway, because we don't really allow any sex offender crimes to be expunged.
So can I just ask, so Senator Sears, were you saying that you think it should be sealable or should not be sealable?
Thinking that certain crimes at the discretion of the certain violations of the sex offender registry might be expungible, although I'm not sure it violates federal law or anything else, but it's something that I was just using as an example because I remember writing that law that made them misdemeanors.
Right, but under the House proposal, they are prohibited from being.
Right, and I'm saying should some of those be added?
So you mean removed from the list?
Allowed to be.
Because,
Allowed to be eligible.
yeah,
But it wouldn't do, but on the other hand, as I think about it, it wouldn't do any good because all of the crimes that are sexual in nature are not expungable, are not sealable anyway.
Well, you could you could have a carve out for this one for failure to comply. Definitely there's no sex crimes that are expungable, but now, or under this new proposal, but for compliance with registry, you can decide wherever you want to go with that. If you did want to make it eligible, the court still has to find that it's in the interest of justice. So it's not an automatic.
Well, I guess my question would be, why would we do that?
Yeah, I more I think about it, it's probably a bad example.
well, I think that I think of the people who are, and I'm not sure how to put this, but the people who are on the sex offender registry who are non-compliant because they're required to take a particular rehab course or whatever you call that, but it isn't offered in their area. So they're not non-compliant because they don't want to comply. They're non-compliant because the program isn't there. So should they, I don't know how.
Let me just look up the underline, because I think it goes more to the issue of failure to register, failure to keep your address updated, things like that. But let me double check.
Yeah. So I went through this list.
Where is the list?
The list is on page 4
Of the new bill.
of the new bill. It starts on page 3, actually. There's a couple on there, but voyeurism wouldn't be allowed to be expunged.
Okay, that could be
And
expunged.
cruelty to animals. Neglect, related to neglect of duty by a public officer.
That's the one that I had problems with at the very beginning, remember?
I mean, why, what,
So like you're serving on a school board and you don't observe some regulation of the state.
or you don't go to the meetings.
No, that should be taken.
Yeah. I don't understand. why
Well,
that's-
what is the crime of, I don't know if that's a criminal offense, not going to meetings. I think I need to have the statute, actually section 306, before we do that. We should know what's a crime. I don't think not going to meetings is a crime. It might get you recalled or it might not get you reelected, but I don't think it's a crime. What is the crime of neglect?
I'm gonna read it to you in just
Okay.
a moment. What's the
Good.
citation?
3006.
And also just to clarify on the failure to comply with sex offender registration notifications, you can't compel someone to participate, as you know, in treatment. But the issue around the violation is that, you have certain reporting requirements and you have to keep your address updated. You have to do those things. If you fail to do those things, it's a violation and it's a misdemeanor. That's the one that's on the non-expungable list right there.
Okay, I see.
So I'm sorry, 3006.
006, neglect of duty by a public officer.
Well, this is not going to clear up much. A state, county, town, village, fire district, or school district officer who willfully neglects to perform the duties imposed upon him or her by law, either express or implied, shall be imprisoned not more than 1 year or fined not more than $1,000 or both. So this list, just to tell you, and I think I talked about at the beginning, the House didn't come up with any kind of new list. What they did is they used the recommendation of Justice Oversight, which was picking up the list that where things left off with S7 last year. So I don't know the evolution in terms of like, I think it was based on testimony and from folks, perhaps maybe it was the league or someone who said, this should be not an expendable offense or something, but
I'd like to hear from them
Remember,
about
any
why
discussion.
it seems really silly.
right. I'm just letting you know that this list has been around since last session.
Well, I
so
think
it's
if
not
the
a new
committee,
list this year.
if the committee wants to make this expungable, I mean sealed,
Yeah.
we can do that. I was going to ask you, what is aggravated disorderly conduct? That's 10026A of Title 13.
Yeah,
That's the guy blowing the horn on Route 302 in,
Right.
But he could never get that sealed.
That
It does not.
sounds kind of silly, frankly.
Is it,
It's 1026A.
disorderly conduct? Could that also be like a fight of some kind?
Aggravated disorderly conduct.
Yeah, aggravated disorderly conduct was what we were labeling that guy that was blowing the horn to us. That's why we passed that piece of legislation.
Right.
So you've got a situation where, in that situation anyway, it should certainly be at least sealed. But I had another question in a totally different concept. Are we?
Well, can we get, what's the definition of aggravated, Michelle, before we, 1026A?
1026A for aggravated disorderly.
Yes.
That is, a person is guilty of aggravated disorderly conduct if he or she engages in a course of conduct directed at a specific person with the intent to cause the person inconvenience or annoyance, or to disturb the person's peace, quiet, or right of privacy, and engages in fighting or in violent, tumultuous, or threatening behavior, makes unreasonable noise in a public place, uses abusive or obscene language, or threatens bodily injury or serious bodily injury, or threatens to commit a felony crime of violence.
Those are ors.
And.
No, I would
You have
say
to
that
do
that's
all of them?
ors.
They're ors.
But there was a.
Well, there's the and, there's like the first part, the lead-in, which is you engage in a course of conduct directed at a specific person, intent to cause inconvenience or annoyance, or to disturb their peace or quiet, and engage in fighting, or make unreasonable noise, or in a public place, or using obscene or abusive language, or threatens violent injury or
So
serious bodily
you
injury.
engage in fighting or threat directed at a specific person.
Right,
or make a lot of noise.
right, but it has to be a course of, it has to be a course of conduct, not like a,
Course of conduct.
not a one-off. It has to be a course of conduct at a specific person with the intent of annoying or disturbing that
Could
particular
this
person.
not, like, criminal threatening, when we were talking about
But
whether.
the question,
Oh,
right, no. But the question for the committee really is, should this be expungible? I mean, sealable?
Well, it seems to me that it's pretty broad and that somebody who has a neighbor who blows their horn all the time, and then he decides to stop blowing his horn because it's not really annoying the other person anyway, or who swears a lot when he walks by somebody's house intending to make them angry. I mean, it's pretty broad.
I would say yes to your question, because at the end of the day, it's still the judge deciding whether or not it should be granted.
Yeah.
Right, and it's after is it 3 years for misdemeanors? Or 2
Correct.
years?
It's 3 years that you have to wait from the completion of sentence. It's interesting, just in case this informs your decision, is that the penalty, it is a misdemeanor, but it's only a 180-day misdemeanor. It's a max 180 days. So,
Yeah.
you can have lots of reasons for why something's sealable or not sealable, but it's not even anywhere close to the maximum. Like, you've decided the penalties is actually rather minimal for a violation.
I would think that.
Yeah, I'm fine with
So,
with
Dick,
that.
can I ask this? Okay,
Okay.
I'm just curious, are we deciding that we're moving away from expungement altogether into just?
Well, I think there's two choices. I think the Attorney General's office gave us one choice, and I proposed a different choice, and that was going to sealing altogether, but using the juvenile model of sealing records.
I'm just looking at the bottom of page 14, where a person can file a petition under A1A. If the person was convicted for an offense for which the underlying conduct is no longer prohibited by law or designated as a criminal offense, why wouldn't we want to expunge that?
I think those are excusable, aren't they, Michelle?
So so what I would say on that is, they were following the recommendations of Justice Oversight, which is one track system, but that within that one track of sealing, you are determining access based on a number of factors. There is no access to a sealed record under this particular provision. So it is in effect the same as expunged, in the sense that there will be no looking at it for sentencing purposes, no DOC access, no Leo access, no anything. So
why does it exist?
So why does it exist?
Yeah,
I
we
don't
have
know what
taken
you
a
mean.
choice as a society not to have this be a crime anymore. Why would we keep any records for any reason in a situation where we have declared this is no longer?
You can decide to carve that out. Again, I think it's just going back to saying that, do you want a 2-track system and then continue to have, you go over here for these types of things and over here for that, or do you have 1 track and limit the access?
I think the question depends on the limited access, number one. And as Marshall Paul was saying before the break, the Defender General supported going to a 1-track system because the access was effectively of sealing would be effectively what they had under expungement. That the part of the problem for the court was the amount of work it took to get things expunged and records that are, in the archive somewhere. So I think that goes back to that. Every question here gets answered, I think, unfortunately, by what track you take in terms of who has access to the record.
Yeah, I do understand the predicament, but I just don't understand why we would have a record of anything that is not any longer an offense. That makes no sense to me at all.
I would agree. We could expunge all those.
Because.
Just the way we do for, we still expunge deferred sentences, for example.
Well, that's what I mean. So when we talk about going to a one-track system, again, we're not being really accurate because there will always be this certain number of offenses that will be expunged, right? As opposed to sealed.
Right.
So.
Committee wants, I'm sorry, Phil, I broke in while you were talking. Go ahead.
Yeah, so I'm just saying that if we're always going to have perhaps a very small number of expungements, we could add this to that, but in the main go to one big sealing system with controlled access. So
what would be the access necessary for a sealed? I mean, if you're going with one track and sealed is the same as expungement, then nobody would have access. You go with it, right? With one track, we're sealing these records. They're sealed, they're done. Nobody can see them again ever.
Right, and you can decide what access, if any, you want to give to sealed records. What the houses decide is they put in certain limited circumstances.
Right.
So, you know, for certain crimes, there's a timeline on which courts can look at it for sentencing once it's been sealed. For DOC, same kind of thing. Agencies have it if they need to defend themselves in litigation related to the matter. But generally, it's as if it were expunged. So if it's outside of those, and then you can limit, you know, you can break it apart depending on, you know, the types of offenses, you know, the way, again, the House proposal does it based on that kind of timeline. So misdemeanors, you get a look back for this long, that kind of stuff. But you could go to something different, like what you have in the Title 33 for juvenile, which is that nobody has it unless you petition and you assert the basis for why you want access, and then you only get access to your own records. I mean, there's a host of options. I think it's more of an issue of, I think part of the directive to justice oversight and what you guys have seemingly been trying to do is try to simplify the process, because what you have, I think everybody would agree right now, is a pretty complex process that is hard. I mean, for me picking this up, this is my first year working on this, since Bryn had done it for years. It took me a lot of work to get up to speed to really just understand how it works now and how the changes and stuff. And so I can't imagine what it must be for somebody who actually has to go through the process.
Well, can I just say that for me, part of my goal here is to get a bill that the governor would sign. And it was indicated to us when we had the testimony from Commissioner Sherling and the testimony from Jay Persing Johnson that there may be an avenue of support if we follow the Juvenile Ceiling Law. That's why I'm suggesting that. But I totally agree, Joe, and I think and Phil, that it makes sense to, if it's no longer a crime, it probably should be expunged. And we've made exceptions for deferred sentences that have always been expunged. And probably if it's no longer a crime, like marijuana possession under a certain level, there's no longer a crime, then it should be expunged.
Right.
So,
I mean, we can draft it that way. Yeah.
Can I just, so I'm a little confused by, and maybe I didn't understand the administration's position, but my understanding from DPS and law enforcement was that they want to retain their access to sealed records the way that they currently have access to sealed records. They don't have access to sealed juvenile records unless they follow the 519 process. So maybe that 519 is okay with them, but that hasn't been the testimony in general for the last few months. So I don't know if we're gonna have them back.
I'm sorry, Michelle, but I'm basing it on the testimony of Commissioner Sherling. I asked him if they would be okay with the juvenile process, and he said yes.
Okay.
That's all I'm basing it on. I believe I have the correct testimony. I believe that's what he said on the 16th of unsealing. Let me, Commissioner Sherling, my note is criminal justice exemption for deferred and juveniles would be satisfied with juvenile. That's my note from the 16th.
I wonder if you would stick to that if we brought it in and presented it.
Well, I can't.
Can we have him in again? Make sure he's.
Well, I don't. Yeah, we can have him in again to see if he still has the same response, but why would we ask him the same question again?
Senator Sears, I like the direction that you're talking about, which is the juvenile system. And I favor as few carve-outs as possible, preferably none, with a judge acting on pleas to get access if somebody needs it. I just feel as though what we're likely to run into is multiple attempts between now and the end of the process to expand it or create carve-outs. So I think we should do what we think makes sense, but I don't know that at the end of the day, public safety is going to be on board with what we do.
Okay. Well, my suggestion is that if that's what the majority of the committee wants to do, that we have a draft, and what we normally do is we get a new draft and we go over that draft and we invite all of the stakeholders into the committee and they can give their views on the draft and whether or not they support it or not. So, that would be my suggestion, and that the new draft include eligible crimes. Neglect of duty by a public officer. Again, it's for sealing. It doesn't mean the crime isn't any longer and a violation of aggravated disorderly conduct.
Okay.
That we
And then
include those two misdemeanors. Are there any felonies that we want to include? Probably not. Uttering a forged instrument is in here, right, Michelle?
Oh, what?
I think it is.
I think I
Uttering the charged instrument.
If you claim
Yeah.
you have.
There's designated felony property offenses, and does this mean they're included in sealing or not?
they are.
So that these can be sealed.
Correct.
No, the other ones can't be sealed.
For misdemeanors, it's
Right.
all misdemeanors
Except
except the
these.
list. And for felonies, it's no felonies except the list. So it's the opposite. So
So fraudulent use,
so the
forgery and counterfeiting is on the list.
it's on the list, as
So-
long as well as forged counterfeit.
Right, so those are expungible, are
Yes.
sealable.
Yes.
Okay,
Could that be, not counterfeiting a check or something, but could that be somebody who actually counterfeits US currency, or would that be the federal version?
that would probably be federal.
That shouldn't be expunged.
I don't know the extent to which those particular statutes are used or what they use them for typically.
'Cause counterfeiting seems like,
That's big time.
yeah,
and they'll do it again.
I
We
think
can
it's
take that
more
out.
than we're talking about in terms of money, but I would say want to talk with the state's attorney.
Well, it
about
says
how they-
counterfeiting, it says counterfeiting paper money. If the committee wants to remove that, it's fine with me.
Which one is that, 1801 or 1802?
Yeah, that's pretty.
1804.
Or
That's pretty
1804?
bad. Page 6.
And somebody will do it again, because
I mean,
it's a big
You
profit.
gotta get a printing press. You gotta-
1802 is where I've seen people charged with uttering a forged instrument for trying to use well, I get forged or counterfeited, but uttering a forged instrument has been used for people who try to draw money out of their ATM and they don't, and their ATM is no longer valid. So
You can get charged for trying to do it if you don't succeed?
Yeah, I'm guilty of that.
Yep.
Sometimes I think
Oh, my God. So when my check didn't go in and I went to the ATM to get some money and the check wasn't there yet, I can be charged with uttering.
so you can see it.
I think
You're all
there's-
set.
I will say that I know that list on the property offenses did come from the Sentencing Commission, on which the state's attorneys were a big part of proposing that list. So,
Is there a mens rea element to that?
pardon?
Is there a mens rea element to that? It's not
Well,
you simply going to plug in your credit card, not knowing that you're overdrawn. We have to purposely.
yeah,
try
no, it's knowing
Yeah, you have
that,
to
knowing
know,
that you,
knowing the same to be false. Well,
Yeah,
I'm
the
looking at
person-
uttering a forged instrument.
the person that I know who got charged with that knew that there wasn't sufficient funds in his ATM, in his bank account, but tried to get the money out anyway.
But if he
Using
didn't
the,
succeed, why would we care if he tried?
because evidently the bank cared.
Well, when you put your ATM card in, you say, I want to get $200 out, and there's only $20 in your account, it says decline. The
Right.
bank doesn't suffer.
Yeah, they don't.
Well-
they're not giving you the money.
That's-
The person knew that they didn't have any money in the account.
Right.
So I'm just telling you that they were charged and the person received the deferred sentence, so it's now expunged anyway.
So when we have the new draft, we had, or I had on mine, remove sections 3, 4, and 5 on page something here. Oh, it's on I've got 2 copies of it here now, so I don't need a new copy every day. It's on page, oh dear, I'm looking at my old copy. It's giving the DOC, the access and.
Well, I think Senator Sears is asking me in the next draft to remove the exemptions in the bill as passed by the House and replace it with the process that you currently have in juvenile law. Is that
Correct.
what you'd like,
Yes.
Senator Sears? Right.
Yeah.
Oh, no, so then we won't have.
Right, so you won't have
We
that.
don't have, okay, great, okay. Yeah, got it.
Doesn't matter. We can't find the page.
I don't know why I have 2 copies of this here.
Because
Because everything was moving so fast there, you guys took it up before it had
Oh.
officially crossed over.
Oh, I see, okay, got it.
Okay. So, and then how long do you think can we take this up again next week? Are we scheduled this week for this again?
I think you have some time on Friday morning, maybe to deal with this and adoption, or did that change?
No, we got rid of the ceiling,
Okay,
we just had
okay.
adoption.
Okay.
So no, we don't have it.
So if we were to take this up again a week from today, would you have a new draft available that it could
Sure.
be sent out to the stakeholders and
Sure,
we
no
can
problem.
ask them to join us and they can pick it apart or say they love it or whatever they want to do.
Sure.
Some will do both.
So are we pretty well settled that The only things in terms of the criminal offenses, the two misdemeanors that we would add to eligibility for sealing would be the aggravated disorderly conduct and the neglect of duty by a
Public official.
Yeah.
Sort of freezing. Now he's back.
Was there anything else on those, either of the crimes?
So can we plug in expungement of the non-crimes anymore?
Yes. Yeah, I thought that was, you wanted to do that too. Of something that is like marijuana possession that's no longer a crime would be automatically expunged. Similar to the way we do for deferreds.
Right.
I think that's only fair.
Yeah.
So you would, so there would be no requirement to petition and it would be expunged?
Yes.
Make it automatic, committee, or
What's that, Nick?
do you want to make it automatic?
If it's no longer a crime, I think it should be automatic. I don't
I
think.
don't like automatics.
Well, the only problem with automatic is that it might have been pled down from,
Absolutely, most, yeah.
or there may have been other crime there. Well, even if other crimes were involved, those aren't expunged anyway. So
Right.
So still have petition, still require
Did
the judge to
Shumlin-
find it in the interest of justice, but just make it expunged instead of sealed.
Shumlin made people apply for the pardons for marijuana possession. Am I correct?
You know, I don't recall. It feels a little familiar at the time, but you know, we didn't, when you decrimmed, that was, you know, 2013, 2014. And so we didn't have the setup for this sealing and expungement process. It might have been more of like the only route at that time.
Well, I think whether it's automatic or not is a policy consideration for the committee. So go with non-automatic, and then, you know, people can apply. And because you wouldn't be able to find some of the people anyway. I don't know. So, but it's a policy choice we can make, and we can hear from people on both sides of that. It's not automatic sealing under the House version, is it?
No, no, it says.
No, you have to petition, and then, but it's, there's no requirement that the judge find it in the interest of justice or anything like that. So the person does have to petition the court for it, but it's kind of like a perfunctory, yes, it's no longer a crime, it's now sealed, and there's no access at all, period.
So if you write it just so that it's now expunged, and then the committee can make a decision whether it wants to go with the, you know, making it automatic or not. But
You know,
just follow the House version, except make it expunged instead of sealed.
Okay.
Sure.
Anything else? I won't be on the floor today, so, but I don't think there's any judiciary items on the agenda, on the calendar, excuse me.
I'm still hoping we can revisit that language on the penalty where it's willingly discloses in the course of official duties. So I don't know why it would be limited to in the course of official duties. And I also have a question about whether we should be looking at access as well.
Oh, okay, yeah. Yeah, I know the section you're talking about. Yes.
Yeah.
Michelle,
And it's in the other bill too. I think it's in the miscellaneous bill too.
yeah. Do you know the section that Senator Bruce referring to?
I'm sorry. I
It,
didn't-
we talked about it before, the penalty for willingly disclosing. in the course of-
Authorized disclosure. So
access.
on my version, it
Also, should it be limited just to in the course of official duties, or should it be unauthorized disclosure?
Okay.
you do it.
Won't be on the floor, Dick?
No, I'm here in Bennington
Okay,
and I can't participate.
I'm trying to remember, is there any bill coming up?
There's nothing judiciary that I could see on the calendar.
Okay,
Okay.
The only thing I won't be here, but I thought my questions regarding that hunting with dogs issue was making that effective on passage is difficult. So I don't know if anybody else felt that way.
I agree with you. Were you proposing an amendment?
No, I wasn't, but I was hoping the Natural Resources Committee would take a look at it.
Have it be July 1 instead.
Chris did say that they asked specifically and the department said they could do it on passage, but
Seems
I
like,
think Dick's right, it doesn't make sense to. But
so do you want us to ask about that again?
No, I just, if something comes up and I'm not there, you might, since I was asking about it, but knowing that other people are in agreement that it just sounds like it's difficult for people to know that
Yes.
you have to do this now.
That's right. It should be where the normal bills go into effect, which would be July 1.
Yeah.
It's always in my mind that it should be then, because then it's predictable.
yeah,
There's other things people don't know about, they don't know to call Michelle or
yeah,
somebody else in ledge council and ask. The general public doesn't know to.
It's a nice bill, though, isn't it?
it's
Anyway, have you got that Michelle, have you got the section on the unauthorized release of the information?
yes, she got it.
Okay, so we're good with that. Are there any other changes we want to look at in the future draft?
And
All right.
Michelle already knows to direct it to justice oversight,
Yeah, the study. But is the study out in the House bill?
So what it was in the House was, it was just 2 members from the House and 2 members of the Senate working with Ledge Council to come up with a proposal for automatic sealing. The House Appropriations did not want to, I guess from a funding perspective, to do that. And then they had thought about having Justice Oversight do that, but because in last year in S7, you had Justice Oversight come up, deal with this issue last year, but Justice Oversight did not feel that they had the capacity to deal with it because of it's such a niche issue and very complex, and there's very few people on that committee from Judiciary. Is they weren't able to answer most of the questions you asked them because they didn't have the expertise. And so the House took it out because they said they didn't think as though Justice Oversight, I mean, if you go back and look at that memo, and I had staffed oversight on that issue, they didn't have the, you know, the way that you guys are steeped in it, they didn't have the expertise to really take that on, frankly.
Then just leave I don't know to study it anyway. You know, if we get this thing through, we should probably let it settle for a few years and some other future legislature can take a look at automated.
and it sounds as though technologically, as the longer we wait, the better, because
Yeah.
the software is getting quicker and cheaper and
I will say that one of the things in the Justice Oversight memo to the standing committees was that they supported the policy of moving towards automatic sealing and expungement, but they felt that considering the current backlog that exists in accomplishing what you've already asked to be sealed and expunged, that Justice Oversight felt as though it was a little premature to add to that at this time. So
I think that's probably wise. We will just follow the House and take the section. The section's already out, right?
correct. Good.
Just leave it out then. I thought it was in because I was looking at draft 5.2.
Right, yeah, appropriation struck it on the floor.
Okay. All right. We'll see you all tomorrow in person and see you and some of you in appropriation.